Good afternoon, everyone. My name is Jennifer Strofe. I'm part of the Student Education and Admission of the Bar Committee of the Florida Bar. And today you are joining us for our presentation on the attorney-client relationship. We have a number of panelists that are going to be joining us, and we're going to be having a basic conversation about the attorney-client relationship, how to handle it, how to handle any pitfalls, and then where you can go from there. So I'm going to start by having our presenters introduce themselves. I'm going to go in alphabetical order just to make it easy. The first person is Josh Magnuson. Sir, will you go ahead and introduce yourself?
Sure. My name is Josh Magnuson. I'm an attorney in Clearwater, Florida. I'm also chairman of this committee. This is a very important, I think, topic for all lawyers, young and old. I practice in a firm that has about 40 lawyers. I predominantly do litigation. I call it dealing with property and money. I do a lot of trust estate litigation. I've also done a lot of commercial business, real estate litigation as well. I think there's nothing more important than lawyers serving for their clients and handling the client's needs and helping the clients set their goals. So I look forward to this discussion.
Okay, next I'd like to go ahead and have Takesha Miles introduce herself.
Hi, I'm Takesha Miles, and I am the supervising attorney of the Fair Housing and Elder Law Projects at Legal Aid Society of Palm Beach County, and I'm happy to be here to talk about the attorney-client privilege, especially when it comes to low-income and vulnerable clients. I think that is a special part of the practice of law and how we handle our clients who are the most in the most needy situation.
Attorney Armana Rahman.
Hi, my name is Armana Rahman. I'm actually relatively new to the practice of law in Florida. I moved down to Florida about 4.5 years ago. I work with Jennifer Strofe, great mentor, and previously have worked in other areas of the law in estate planning as well as personal injury, and have actually also been a licensed realtor in Pennsylvania. So hopefully I can bring something to this table. Thank you.
Okay, Attorney Rachel Wise.
Hey everyone, so my name is Rachel Wise. I am an assistant public defender in Pinellas County, so over in the Sixth Circuit. So I do exclusively criminal defense work, particularly from the government side of things. So kind of a slightly different perspective than some of our wonderful private attorneys, but it's nice to be able to talk about kind of both sides of everything. So I'm really excited to go through all of it with you.
And Attorney Aman Zerki. I'm sorry, I mispronounced your last name.
Hi, everyone. My name is Iman Zekri. I'm an attorney at Henderson, Franklin, Starnes & Holt in Fort Myers, Florida, and I practice exclusively family law. I've been doing family law since I graduated from law school, and it's been about 1.5 years.
And as I said, my name is Jennifer Strofe. I'm a board certified criminal trial attorney, and I also tutor the Florida bar exam. And I'm the co-chair of this committee. So I'd like to go ahead and go over first kind of what our goals are going to be today. We're going to have fun. We're going to be kind of interactive in our discussion. We're going to learn a little bit about the attorney-client relationship and where to get help. When we talk about the life cycle of an attorney-client relationship, what I'm thinking about is finding the client, setting prices, actually signing that client, communicating with the client, navigating issues, and then ending the relationship. So let's start with finding a client. So Josh, I think you're kind of the most senior person on here as far as amount of time.
Clients come to me in various ways, predominantly either from people in my law firm who may be transactional lawyers who, when need help, when a matter becomes more litigious or there's a problem and they need help on that side, or I get phone calls, or just somebody finds me on the internet or finds me out there and they call. So you may just get somebody to come to you via some electronic device. So you got to be really careful right at the beginning in terms of the idea of finding clients. I don't want to get into the whole advertising. I want to talk about the relationship part. I think it's very important when you first get together with a client either over the phone or in person, that you actually meet the client as a person first, as unless there's something that needs an emergency, because there's a lot of issues that I think need to have dealt with preliminarily, that you want to work out with the client before you really get into giving them advice. And to just give them advice over the telephone or from an email, I think is not very helpful. So I would encourage you that in terms of finding a client, or when you first meet, you actually try to have a conference. I actually give 30 minutes to an hour of free legal advice. I have a consultation that I don't charge a client. So I encourage clients to come in and talk to me, or Zoom or whatever it is, if there's COVID. But I think it's really important to meet, the person and get to know the person and get them to know you.
Amon, how do you get your clients in?
So in family law, a lot of our clients are coming from referrals from other attorneys. So they're either attorneys that don't practice family law, so they'll send them our way, or they might be attorneys in different parts of the state who know, we practice family law in Southwest Florida, so they'll send them to us. We do get some, we call them duty day calls, where it's individuals who've either done an internet search or they've come across our law firm's phone number and they call the main line trying to get connected to an attorney, and we try to route those to the appropriate department, because my firm does have, a department for almost every area of civil litigation that's out there in transactional work. We do everything but criminal law, so those we have to refer out to other attorneys if it's a criminal law matter as well. But I would say networking is a big part of it. It's important to go out there and meet attorneys because they will be your referral sources for cases. And I agree with everything that Josh said about the importance of, meeting with the client in person is preferred, so that you can get a sense of their legal issues, give them, an honest take on your perspective of the case and what issues you think that they might have. So that's super important. And also just being clear when the relationship starts of, you have to retain us, you have to sign this engagement agreement, so that it's clear, when you're representing them, or also when you haven't chosen to represent them as well. So that's important to be clear on that aspect, so everybody's expectations are on the same page.
I know when I was first starting out with my private firm, the two things I had to watch out for were what I put on my own Facebook page, what I put on my internet website. It took me actually referring back to the rules of professionalism. And the issue that just came up a few weeks ago that I thought was funny was my mom. Moms are very helpful. They're going to try to help you. And my mom's like, oh, well, just give me a stack of your cards. I'll start handing them out and doing this. I'm like, no, 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 no. I'm like, mom can't do what I can't do. Please, mom, don't start throwing them out when you see a car accident on the side of the road. She's like, well, I saw someone get arrested the other day. I'll just go give them your card. And I'm like, no, 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 no. Let's not go run after the people who are in handcuffs and hand them my card. So again, moms and family are helpful, but just watch out, because again, you don't want someone to do what you can't do. And you want to be careful if you have employees or friends and family, if they're posting on social media on your behalf, or even what you're putting on your own page, because you don't want to accidentally be soliciting, or heaven forbid, in-person soliciting of a client. So let's talk a little bit about, Josh mentioned it and so did Amon, when that client relationship happens, because, most people think, oh, well, I didn't put pen to paper. Is that really a client? I think we've all heard the story of, the guy in this small town who's getting a divorce. So he runs to every single divorce lawyer within 20 miles and pitches them the case just to make sure the wife can't get representation. When does an attorney-client relationship start? Rachel, what about you? I know you're in government, but do you have a problem where sometimes an attorney-client relationship starts and you need to know it?
So we more so have a kind of a problem where a lot of times the clients will think a relationship has started before it has, because as a PD, there's kind of two different ways we usually get appointed to cases, or at least two different times. Since I work for the public defender's office, I exclusively can only work for people who can't afford an attorney. So when they get arrested, if they have a case, say like some kind of lower misdemeanor where they are able to bond out very quickly, or they get ROR, so they don't ever go in front of an advisory judge, then they get appointed usually at their first court date. So sometimes that means their case has been pending for 6 weeks. And so they assume they already have had a lawyer appointed, or they come in and they don't know the process itself. So a lot of times they'll come in at their first advisory date, or the first arraignment date, excuse me, and ask, okay, who's my lawyer? What's going on? Can you walk me through the case? And we're like, hello, I've never met you. Can you tell me what your name is? So that we can look it up in the system and try to figure it out. So a lot of times we'll have clients who assume that they got a public defender at an advisory hearing that they weren't at because they either paid their bond or they got an ROR release. And so they won't know that they haven't officially had us appointed. So sometimes they'll start talking about their cases or the facts of it. And we're like, wait a minute, we're not on your case yet. We don't have even a 1-page sheet of what's going on to be able to advise you, even if we have been appointed. And then other times it'll be the opposite, where if they got an advisory hearing, like if it was a bigger felony, or if they just couldn't pay the bond and they went to an advisory hearing, they'll get appointed a public defender, but it takes usually under about 3 days or so to actually be assigned an attorney. So sometimes they'll come in and say, okay, who's my public defender? And they'll just talk to whoever happens to be in the room that day, but it might not be me who's actually assigned to their case. So we a lot of times have the issue of figuring out when a public defender comes on, and then clients sometimes get confused of when they actually find out who their public defender is. Like at arraignments, when we actually do a lot of the appointments, sometimes they'll talk to me if I'm just the one who happens to be free, in the 2 minutes that the judge is addressing their case, but then I'm not the one who actually gets assigned to their case itself. So it's kind of a unique PD specific situation, because technically they can talk to any of us, but it might not necessarily be my case. So a lot of times ours is when it becomes it.
Well, I think when becomes a problem too, even if you're in private practice. Armana, I'm sure you have friends and family who walk up to you and start asking legal questions, or worse, when they say, I'm not asking your legal opinion, I just want to know what the answer is. So what do you do, Armana, when it's friends and family that are calling for non-legal legal advice?
You say, call your lawyer. I try not to give advice. I really do. I refrain from that. You don't know the facts. You don't know the situation. You don't know what the backstory is. And I don't want to be on the hook for something where I just have very basic information. So yeah, I just say you have to get somebody to represent you, and you have to tell them that complete story. And I'm not that person at this time, unless you choose to engage in that kind of relationship at some point. But definitely I shy away from that.
Yeah. And I actually did have that happen one time. My best friend texted me and she said, I'm not asking your legal opinion, but this is the case. Someone got arrested in this, this, and this. And I wrote back, my only opinion is my legal opinion. Call me if you want to retain me, but don't call me if you don't. Otherwise, talk to someone else. So it's not just about if there's an attorney-client relationship, it's about when it starts and then when you do pricing, et cetera. And beyond pricing, they're setting expectations. Takesha, I know you have kind of a unique situation because you deal with both elder law and other people who are vulnerable. Do you have prices in your situation?
No, all of our services are free. So we are a complete legal service program where all of our services are free. But the demands of the client still are as if they pay us and expect the 24-hour service. But I did want to address one issue that's very unique to legal service attorneys, is that we help a lot of pro se individuals. So we help them do an answer to an eviction. And then they walk out of here with our, pro se form, and then go tell the court, well, my lawyer at Legal Aid said X. And it's like, no, when we give you the paper and we don't file the paper ourselves, you are representing yourself. And I think sometimes that's, they've retained us for a service, and it's always important that our attorneys are clear the limits to the service. And so we do a retainer agreement, just like people do in a private practice. There's no exchanging of funds on the retainer agreement. We were definitely specifying that our services are limited, whether it's limited appearance or limited representation. We're helping them with pro se assistance with preparing a document or filing, helping them a document to file, or we're going to fully represent them. And I think sometimes, especially in the legal service area, a lot of times clients come to us, they're in emergency mode. They just came from the courthouse. We're 3 blocks from the courthouse. So that is our best referral source or not. But they come to us, it's an emergency. I'm getting evicted. I'm being garnished. And so they expect the information right on the spot. And the expectation has to be set on the onset that what the limits of what we're providing for them so they understand we're not going to be in court with you, even though we're giving you a paper about how to handle your case.
And I think there's a couple of excellent points there, and I'm going to go to Josh right after.
Okay.
First, not all fees have to be in writing in Florida. Contingency always has to be in writing. It is a good idea to have every fee in writing, though. Even if you can get around it, like you look at the rule and you're like, well, technically it's a service, it's this, and I don't need it because it's going to be completed within a year or it's going to be less than a certain amount. It's just easier to have them all in writing. So you do know when that attorney-client relationship begins. But to Keisha's point about the fact that you set an expectation, because a lot of people will say, this is my lawyer. I will represent someone once in, a domestic case or a traffic ticket or something else. And then they have a family law and eviction come up and they're like, that's my lawyer. I can tell you right now, that is not my area of competency. So I am not your lawyer. I'm happy to refer someone, but they just assume that once I've touched something that I'm there forever. And Josh, you can expand on that point and address what you wanted to address too.
Well, I think Takesha brought up some really good points. Number one is that you talked about the expectation. The scope of what you're doing for the client needs to be defined. Every lawyer should do that in terms of in their representation letter. And like Takesha said, what exactly are you coming? What services are we providing? Every lawyer should do that so there's no misunderstanding about the length or breadth of what services you're providing. So I would say, yes, you should have it in writing and you should define what they call the scope of representation. The second thing that I wanted to point out is at the very, very, very beginning, make sure there's no conflicts, okay? So before you start getting the client to start talking to you about what the problem is, but you can't stop because they're going to already start telling you, is tell them, wait a minute, let me just find out some basic information first. Who are you? What's the, who are the possible parties on the other side? Let me get some names. And if you're in a firm like Iman is, you might want to circulate that before you have that initial consultation, before you sit down where the client starts to divulge confidential information. Now, Takesha, I don't know how you do it because people are coming right in, already telling you the story, already telling you everything. And all of a sudden you realize, wait a minute, I just had somebody on the other side come into me yesterday because it happened. So I don't know how you deal with it. And then the last point I wanted to make was about money. You got to talk about money right away. How much is it? People want to know if, we're not talking about free services, or from the government, but if somebody's going to pay you to work for them, you need to have a very serious conversation about how much money you want to be put in deposit, how much you charge, how you bill, all the questions about billing. Don't be afraid to talk about money up front. But Takesha, I'd be curious to see how you deal with the conflicts in your situation.
And I think that's where we'll go right now is we'll talk first about conflicts, and then we're going to come back to different types of fees. So Takesha, why don't you go ahead and answer us for what you do on conflicts? Because you're right, walking right from the courthouse, I can see both parties walking in the door.
Yeah, at Legal Aid, that's one big issue or conflict because not only we're 21 different projects in our office, but we represent victims of domestic violence. We represent children in the foster care system. So you can imagine that there is some sort of criminal incident with a child. Maybe the landlord decides they want to evict, and now the parent wants to come to us to protect their rights for the eviction. But our foster children's project is representing the child in a case. So, that is probably the hardest thing is, because we take walk-ins. So any given day, someone can walk in because they've been sent here by the courthouse or our names on the summons. If you cannot afford a lawyer, call legal aid. So we don't have to do any advertising. And so people walk in, they want, I got this writ of possession. And so they want to, what do? I have 24 hours to move. And so, we always have to make sure our staff stops, go in our case management system, look up their name, because we can get ourselves in so much trouble, quickly, wanting to help the person resolve their issue, because it's an important issue too, but also knowing that one of our other 21 projects might be representing the other side. Or the only time conflicts weren't an issue is when we were doing our robust mortgage foreclosure defense project, because I never had a bank on the other side at legal aid, so we never had to look up the foreclosure cases. But everything else has to be conflict checked, because we can run into an issue any day.
And Rachel, I'm sure you guys see plenty of conflicts. How do you actually do a conflict check?
Sure. So we do deal with that a lot at the public defender's office. We get a lot of co-defendants if two people are arrested at the same time, and we get a lot of cases where if someone's a witness on another case, there can be a conflict, or if it's an alleged victim who also happens to be a client, we deal with that a lot. So one of the first things our office always encourages attorneys to do is to do a conflict check in our system about as soon as you get the case file. I know it varies a little bit from offices to office, but with ours, we go in and check, and we can run a search to see any open cases that have that name attached to it, whether it be as a witness, as a client, as an alleged victim, and we can look and see if there's any specifics there. Now, then and this is where I think it probably varies a little from office to office, but from ours, we look to see exactly what the nature of the conflict is and what the seriousness of the cases are. Because the biggest thing with the PD's office is a lot of times we have a ton of cases going at once. And so you have to figure out which one to conflict off of. So we always try to stay on, the more serious cases, like if someone has a felony or a capital case versus the other person has like a misdemeanor, we're going to try to stay on the capital or the serious. But if you've already talked to that client and gone in depth with them and looked at the specifics, you pretty much have to stay on whichever one that has happened with. So our office always tries to encourage you to do those conflict checks as soon as possible. One, so that we don't put ourselves in a situation where we have to conflict off the more serious case because we've already talked very in-depthly with the client on a less serious case. So we kind of have to come off the other. And so that when from our office, if we conflict off, they go to regional counsel, it makes it so that they can have a relationship with that attorney, so that a client doesn't start out talking to us, feeling comfortable with us, having a real attorney relationship with us and knowing what they're going to do with their case, and then us saying, wait, actually there's a conflict, never mind, start over with somebody new. So we try to do that as soon as possible before those conversations happen, so that if there is a conflict where we have to come off, it doesn't create a bigger problem, but it also keeps the client from having to meet 5 different attorneys.
I know now that I'm in private practice, I have a case management software. So what we do is we actually pull up the names as we relate them to the case. And if any of the names come up, the assistant immediately emails me and goes, you need to look at this. And there are also times that I have co-defendants. Sometimes it's husband and wife. Sometimes I've had brothers several times where they have basically the exact same defense. And we are in a position that we can represent both, but we get written waivers of conflict at that point. I have to tell them, one, there's a potential conflict. I have to explain what that potential conflict is. And then I give them a writing that says, here's the potential conflict, here's the problem. And you can go talk to another attorney if you want to. You can think about it, but it gives them a meaningful time. And frankly, one of the things I do on a regular basis is I call the Florida Bar Ethics Hotline. If I am in any doubt at all, that 800 number, it's right on the Florida Bar's website. The ethics hotline is completely free. I literally have it on my speed dial on my cell phone. I think it's number 8. And it's just because I hit 8 all the time. But that hotline, they have real lawyers who staff it. It is completely free. They are not there to be like, oh my goodness, you did this, I'm going to go get you. They are there to help you solve that problem. So that's been very important. Now, we also talked about setting prices and fees, because honestly, the things that are going to get you in trouble with client is lack of communication, not understanding the scope of the representation, and then the fees. So with fees, there are a couple different basic fees that we follow in Florida: the flat fee, the hourly fee, a contingency fee, and then kind of a hybrid fee. Who on the panel does an hourly fee? Just kind of raise your hand. We'll start with Aman, and then we're going to go to Josh. So Aman, how are the flat fees done?
So I mainly use an hourly rate. The only time I do a flat fee is if I'm just reviewing a document, like, and it's simple. So in family law, I mean, it's primarily divorces, but we do get a decent amount of prenuptial agreements and postnuptial agreements. So if somebody's coming to me and they're trying to, get married, and their fiance's attorney has prepared a prenuptial agreement, and they're just looking for somebody to review it, give them legal advice on what rights they're waiving, what rights they would have without the prenuptial agreement, then I'll usually just do a flat fee to review the prenuptial agreement, give them advice, and then suggest any changes to the other attorney. For the most part, for example, divorces, paternity cases, the bread and butter, of a family law attorney, that I'm doing an hourly rate. And I'm very transparent from that first consultation with the client about what my hourly rate is. I also tell them the paralegal's hourly rates. We charge for our paralegals hourly, and then our secretaries, our legal assistants, all of their work is not charged to the client. So I'm very clear about whose work is billable. They'll often call the legal assistants and secretaries if it's something small and they just have a question about a hearing, what time is it, because they know it's not billable. And then if they need legal advice, they know, that's when to reach out to me, and then I'd be billing for my time. And so in our engagement agreement, we not only set out the attorney who's going to be billing on the case, their hourly rate, but we put all of our family law attorneys in our department, their hourly rates, in case somebody needs to cover for the other person, so that it's clear, these are our family law attorneys and these are their hourly rates. So we are very specific, of what we're billing, what they can expect. And like Josh said, you can't be bashful about talking about money. If you're in private practice, that has to, be a discussion that you have with a client. Obviously that's not the first thing you want to say to them, but, they need to know from that first meeting that, this is how we bill. Our firm bills monthly. So I tell them you can expect an invoice every month, know where you're at on your retainer, know how much you owe us or how much is still left on the retainer. So that's definitely a conversation that has to happen from that first meeting with the client, before they can hire you.
Now, Josh, you do hourly.
Yeah, I do
How do you
hourly.
handle it?
Okay. Iman is exactly correct. You definitely want to talk about it. You definitely want to put it in writing. You definitely want to explain to the client they're going to get a monthly bill. They're going to see what you did and the time it took you to do it. And you want them to say and agree that if they have any questions, they will call you immediately or talk to you or set something up to talk about the billing or the payment of the fee. You don't want it to fester. So when you send a bill out, you say to the client, I expect to be paid. These are the services I'm rendered. I want you, I need to get paid. I got people, and I expect you to pay me. I don't think there's anything wrong with having an honest discussion with a client about the money. They don't know. A lot of clients have never hired a lawyer before and they don't know how it works. So the more transparent, I think Iman is correct. The more you talk about it, the more you let them know that you don't mind talking about it. And you prefer that if they have a gripe about the entry of your time, or you're spending too much time, or why did you put too much time on that motion, or how come it needed two people, you're ready to explain it. And you can talk to them about the bill. So that's really important. The misnomer that we have to get rid of is the word retainer. It's not a retainer. The Florida Bar changed the name. You're entering into an engagement with a client. They give you an advance and you put it in your trust account. A retainer is a relationship where somebody pays you and they put you on. That means the money that you get as a retainer is immediately earned, and therefore the attorney is their attorney for a period of time or for a specific issue. But what we're doing when you're doing an hourly rate, you're basically being engaged as an attorney where the money will sit. What I do is I get an advance, which is a deposit that you can draw on, but the money is not earned until the bill goes out. So just be careful with your terms. Florida Bar makes a clear delineation between whether it's a retainer, hourly, or contingency.
No, that's a great distinction, Josh. Now, in practice, have you ever had a client dispute a bill?
All the time.
What do you
Who
do?
doesn't? I talk to them and I explain it, but I say, do you remember when we first met? I said, this is what we need to do. And they do talk. And if they don't like it, then you either have to negotiate with them because they don't like paying. Nobody who likes paying bills. So you either have to negotiate and settle them, or you say, look, I can't stay on this case. If you don't feel that I'm doing the work that I say that I'm doing, and you feel that you're doing the work and they don't want to pay you for it, then you're going to have a heart-to-heart talk about continuing representation.
And I think that leads us into the next concept in general, which is client communication. Armana, I know you said you're newer to practicing law in Florida. Have you noticed a difference between clients' experience with the law or their background or just their knowledge in general in how you approach communicating with them?
I think you have to look at kind of like, yeah, you have to look at their background and where they're coming from. And I'm also often reminded, use as simple language as possible to help them understand. Sometimes we forget that they don't have the acumen that we do, have the education that we do, the exposure that we do to language and people from all over the place. And so we really have to break it down and keep it as simplistic as possible. It is very important to keep communicating, to keep talking, keep those lines of communication open, and make sure that they know that you are listening. And, obviously, a great way to listen is to maybe restate what they just told you so that they know that you understand what they're saying. And that way they will feel like they are heard and you can foster that relationship and help it grow.
Now, Takesha, I know you talked about the fact that you have a population that may not always have lawyers, or they're having to come because they're in a desperate situation. What are some of the barriers you see to communicating with your clients?
I mean, the hardest thing is, technology. Some of our clients can't afford to keep up. They can't afford the rent. They can't afford to keep up the cell phone bill. And that's the worst thing, is when I need to communicate about a hearing, or there's a writ of possession, or there's some issue that I need to, do a quick answer for their eviction case, and then the phone's disconnected. The pandemic has also proven to be challenging, as I do elder law. And so I have a lot of seniors who technology is not their friend. And so to be able to, have consultations and have our initial meetings now by Zoom, some of that's challenging, whether they don't have smartphones. They have the flip phones. They have, phones that are economical for them, but not necessarily technology enabled. And so I think that has been an issue, dealing with technology, and just our clients have, multiple issues that they're dealing at one time. And sometimes, talking to their lawyer is not their first priority. And so, because they've got other things that they're trying to deal with.
And we've kind of, again, these concepts are overlapping with each other, but setting that initial client expectation of communications. I just kind of want to run through the whole panel and get an idea of how people do it differently. Like, Josh, what is your expectation, or when do you tell clients to expect you to communicate with them? Is it weekly, monthly, after every hearing? What do they expect?
Well, first of all, I think the burden is really on the lawyer to make sure that the client is informed. So that's the most important part. I think Takesha's problem, the problems that rise with her are, I don't see those as much. Obviously, the people that I deal with, I have emails, conferences, they come in. So I can communicate. I think the problem that she sees is much more difficult. I wouldn't know what to do if I didn't have a client that I could, go to and find and be able to capture. I've got a hearing. I need to figure out what you're going to say, or what happened in this specific thing, and get some background. That would be extremely difficult for me. But for what I do is I tell the client they can call me, write me, or do whatever they want at any time. I tell them that, obviously I don't work 24/7, that I want it during the workday. If it's an emergency, sure, you can call me or write me, but I want it, that them to have an understanding that I have a life too, and that if they expect me to work just on their case 24/7. I have other clients, I have family, I have other things that I need to do, and I will get to them as fast as I can. I care a lot about my clients. They know I care about them, but I think you've got to set that realistic expectation about communication. But I think Armana's point about listening, most lawyers want, and I'm a prime example, most lawyers want to talk, not listen. But listening is the most important thing a lawyer needs to do. If the more we listen to our clients and help understand where our client's coming from and what our client's goals are, and help to understand what the client is going through, so you as a lawyer can help the client achieve their goals, that's real communication, where the lawyer becomes a better listener and can actually effectuate what the client is asking you to do.
Aman, how about you? I mean, family law, I'm sure there are people, it's 5 o'clock on Friday, it's time to change kids. I'm sure you get all those calls. How do you set up the expectation at the beginning of when you're going to be available and when the client can expect to hear from you?
So we do have a lot of emergencies, like you said, in family law, especially with the children and exchanging of the children. I mean, we have people call like on an emergency basis, like we're there, we're waiting, what do we do? Or, this person's coming to my house asking for the kids. So, I mean, we get a lot of those very urgent matters, and, we try to respond, as promptly as we can when it's an emergency, but we let our clients know, if it's not an emergency, you can expect a response from us, give us, a couple business days to respond. With phone calls, we try to respond in, one business day. If I can't personally call the client back, I'll send an email to my secretary and ask her, can you call them back, see what's going on, and let me know if I can't return their call. The big thing is if you're going to be, out of the office for a long period of time, whether that's personal time off or whether that's even just preparing for a hearing or trial, I always put my out of office, email on so that they know I've gotten their email. It's come to my inbox, but, I'm working on another case. And it also helps them know that, when it's their turn for this big hearing, this big trial, they'll know that I'll block off that time for their case. But, at this time I'm in court for another case, but I'll get back to them as soon as I can. So my rule of thumb for phone calls is like within a day, I'll try to return the phone call. And then with emails, people expect you to be responding to emails, immediately, and that's just not realistic. So I will try to set the expectation not only by letting them know, that these are our working hours and, we're not going to be working 24/7, but also by avoiding, sending emails at like crazy hours at night. Like I know other attorneys will send like emails to clients super late, but I'll try not to set that expectation unless it's an absolute emergency. I will not respond, outside of those business hours because I don't want them to, be sending me stuff, in the middle of the night and expecting me to respond. So definitely just be aware kind of how you're kind of reacting to their requests, but definitely be reasonable, be timely. And if you can't get back to them, let them know. I received this. I'm either preparing for something urgent. I'm in court, but I'm going to get back to you as soon as I can. So a lot of times they just want an acknowledgement, that you've gotten this document, or that you're you know what's going on in their case, and that you'll get back to them. So it's just important about being proactive about those things and kind of trying to always stay in touch with them. And it also depends on the client. Some clients want constant contact. Other clients, they'll be fine for a few weeks without checking in, and then they'll say, well, what's the status of this? Is there anything happening that I need to know? So it's very also subjective on the client.
And Rachel, I know you kind of deal in a volume business, so to speak, just by the nature of what you do. How do you set client expectations with regard to communication at the beginning?
Sure. So I think the biggest thing, especially from the PD side, because while I very much love my work, it is a volume business is about the most accurate description I've heard of it. I try to very early on go through the kind of general process that I do, and then explain kind of the expectations both on my side and on their end. Because kind of like Aman was saying, some clients, they want to check in once a month, see what's going on. Other ones, it's like you get a call every 3 days. It kind of just varies from client to client. And with mine, I try to set it up so that if a client needs to speak with me, that I block out a specific chunk of time. It's usually about a half an hour, depending on the kind of case and what's going on with the status of the case. But I try to set it up so that if you call me and set an appointment, I will block off a chunk of time that I talk just to you. and like I prepare before, make sure I can go through and use that time as wisely as possible, so that we can go through everything, especially because with PD work, especially, a lot of times my average docket is anywhere between 10 to sometimes 40 cases in a day. So if a client calls the day before court, I just don't have time to block out 30 minutes to do that. Versus if I say, hey, call me once a month, or the general rule of thumb I always do is call me between each court date, because usually that's when things are happening. You know, if it's just been reset or we're waiting on discovery or something like that, I say, make sure you've checked in with me between each court date. One, so that I can tell you if you don't need to be in court, you don't drive all the way down there for no reason, but also then I can tell you what's going on with your case. And I try to check in with my clients regardless of if they, you know, if they've set an appointment, but sometimes I just don't have as much time to sit and have an in-depth conversation. So I always tell my clients, this is kind of my general policy. If you want to talk to me about, you know, the good, the bad, and the ugly of your case, or you have a really specific question, set a time with me. I'll make it, and then you know I'm dedicated to sit and talk to you. Versus if a client calls, you know, just because they have a question, or they call a random time. Sometimes I'm in an appointment with someone else. Sometimes I'm in court. Sometimes you get pulled on to be on a trial, which is why I've missed other panels that we've had. That's kind of just the nature of PD life. So I always try to tell my clients, like, I will check in as much as I can, but it's on you to check in with me, you know, every so often. And usually the rule of thumb I say is once a month. And then if they set an appointment more than that, wonderful. But if not, then it's kind of there. And it makes it easier on me too, because I always feel guilty if I have a client that I haven't talked to in, you know, say 6 weeks or something, and I've been trying to reach out and I haven't heard anything back. I always feel bad. But if I've reached out and I haven't had, you know, haven't had a good number, or they haven't set an appointment, it kind of helps with that to know this is the expectation that I have on my end. This is how I'm going to treat your case going forward. And it makes things a little bit clearer. And kind of like Takesha was saying, I have the issue all the time where I'll have a client, we've worked on something, and then the number goes bad. And you're like, well, how do I contact? I actually have a trial next week that's set like that. I'm like, I don't know if it's going because I don't have a good number for the client anymore. And that's, I think, more specific to legal aid or PD work, but it definitely makes it easier to know, hey, here's my number. You can always call, leave a message. If I'm there, I'm not there, and kind of set that expectation early. So that when you do have a client whose number goes bad or they disappear or whatever, you at least have a general idea of how to hopefully help them find you again.
And Armana, I know you've had this issue come up. What do you do when the client kind of disappears? What kind of steps do you take to try to get in touch with them?
Oh boy. Always check to see if they've been arrested again in criminal law. I mean, that seems to be something that we've come across a few times, where if we have sent out a letter certified, if we have emailed them, we have called all the numbers we have, and then last resort, check if they've been arrested. If they're out on probation, check with their probation officers or parole officers. I mean, sometimes it's a lot of hoops to jump through to kind of get in touch, but it's important to keep them, to keep in contact with them, and for them to keep in contact with you. And it can be trying. It can be really trying, especially with our conflict cases. It's a struggle.
Well, I've noticed when I've practiced 20 years now, and the way I communicate with my client has actually changed in the past 20 years. I mean, when I first started practicing, almost everything was by paper letter. And then eventually we kind of migrated to email. And now for most of my clients, we text. That is a personal choice. I set it up at the beginning and I explain to my clients, because there are times I'm in jail, I'm in presentations, I'm in other client meetings, I'm in court. But the quickest way to get me is to just text me. And even a simple text of, I'd like to talk to you by phone. This is when I'm available. I can respond very quickly to that. I've also noticed that this is my personality. I tend to joke a little bit with the clients, and I will joke when I give them my personal cell phone. I say, this is my personal cell phone. So by the way, if you call at 2 o'clock in the morning for a status of the case, the status of your case at 2 a.m. is your case is asleep. So don't try to get your case when it's sleeping. And everybody laughs at that, but it helps kind of trigger in their mind, by the way, there are times maybe it's not the best to call me then. You're not going to get a good response at that moment. And I tell them, in the 20 years I've done this, I've had maybe 10 clients really break that rule. And of course, because I do criminal, the exception is if police are knocking at the door, you may call at 2 a.m. Short of that, it really can wait until 8 or 9 in the morning when I'm awake again. So let's talk about one thing that people don't like to talk about. When the relationship goes bad, this is a relationship. And just like every relationship out there, sometimes it turns toxic. Sometimes it's just not you, it's me. But most of the time, it's not me, it's you. And it's time to break up. Josh, I see you laughing energetically in the background. Have you ever had to break up with a client?
It always brings back this one story, and this it was a woman client, and every time I would tell her what I think we should do, or give advice or talk about the legal ramifications, she would always argue with me. And eventually, we got to the point where she was never agreed with me, always wanted to argue about everything, didn't like what I did. And then when I said, I think you're going to have to get a different lawyer. This is not working. You don't agree with, you don't like my legal advice. What's the point? And she said, no, no, no. You're so good because I love your arguments. You're a great lawyer. And so it's like she put me in this position where I was showing her I could. Anyway, it was just very difficult. It was one of the most odd things. There's two parts to this. One is, yes, the way you tell a client is it's not working. Again, it goes back to what I think Imam said was the idea is you got to be able to communicate and be straight with your clients. And Takesha, I'm sure it's the same with you and with Rachel. The more honest and straightforward you tell them what's going on and what's happening, and if they say, I don't like it, then you have to say, look, you may be better off with another lawyer. It's not working. And then talk to them about the ramifications. They need to know, they need to make a good decision. Do they stick with you? Do they not stick with you? But you got to be prepared. The second point that I want to make on this issue is delivering bad news. And that is always where the problem happens. You didn't, and that means that you probably didn't let them know ahead of time what may occur. So like if somebody gets, the jury comes in, Rachel, in one of your cases where, they think it was terrible, or they had some kind of unreal expectations to begin with, and you come back and you say, a motion for summary judgment was granted because it turns out you didn't tell me about this piece of evidence that the other side had the whole time. How do you deliver bad news to a client? You need to be ready to not only talk to the client ahead of time that the case never looks as good as it does the first time you hear it. It only kind of goes downhill from there. They need to know that you don't know all the evidence. You don't know how it's going to play out. You don't have any guarantees. So the more that your client does not come in with unreal expectations, the better you are. And therefore, when you do deliver bad news, it's not a surprise.
And Takesha, have you ever had to break up with a client or tell them it's just not working?
So that's the funny thing. I think in legal services, we don't break up as much as private practice lawyers. I don't know if we're softies or we're giving them a second, third, fourth chances. So as you asked the question, and I thought back, I've been practicing law since 2003. I've only filed a motion to withdraw 4 times in my career. And that's because I just either couldn't take it because they were berating me or calling me names, or, it's often when the case turns and you have to deliver the bad news. You may have to move out because you haven't paid your rent. You work for the landlord. I don't work for the landlord. I work for you, but we haven't paid our rent in 3 months. And so it's come to the part where we are going to have to move. So I think that's kind of the challenge in legal services. I think we are, although we're lawyers, sometimes we're social workers, sometimes we're, fix my lifers. And so we are trying to fix their life and trying to give them second chances because we know there might be mental health issues or substance abuse issues or something else that's causing this issue, this rift between us. And we're trying to help them no matter what, against all odds. But I think sometimes in legal services, we just don't break up enough. Because sometimes in the interview, this is not going to go well. And, 3 months down the road, I have a crystal ball. I know that this client's going to be challenging. But we're committed to doing the work, so we do the work. But sometimes from the get-go that this may not be the best case for you to take.
Well, and I think there are a lot of good life lessons in that one. One is sometimes when you can tell at the beginning, the hardest thing you're ever going to do as a lawyer, especially if you're just starting your own practice, is to say no to a client who has money in hand. Whether it's you quoted 5,000 and they're like, well, I've got 3, or whether it's a matter of you immediately can tell that you are never going to meet their expectations. Or you can tell just right off the bat, there's a rift there of some kind, but they're willing to pay you and you kind of need the client. It's tough to say no, but getting past that is really a growth as an attorney. And when you're having clients, whether it's you're having a rift, a communication issue, or something else, if you have the luxury of being in a firm that has more than one person, or even if you don't have that luxury, bringing in a second lawyer is sometimes a really great way to handle it. Someone to also listen to see what's going on. I want to talk just really quick about a couple of the resources that are there from the Florida Bar. Might get this wrong. I believe it's lawyers advising lawyers or lawyers helping lawyers. Okay, I got a thumbs up. Lawyers advising lawyers.
Yeah, it's lawyers advising lawyers. It's great.
I didn't know about this until I've been practicing 15 years. And I was a year or so into private practice, and someone had come to me with a real estate issue. I don't normally do that, but I'm like, Bar says I can become competent and do it. So let me see what I can do. And, I did my due diligence. I did all my reading, and then I'd written everything up, and I'm looking at this piece of paper and I'm like, oh my gosh, when someone signs this, something happens. I'd really love someone who does this area of law all the time to just bless it. Even though I'd put in a lot of hours of research, I just wasn't confident because it wasn't my area. So I called up Lawyers Advising Lawyers. It's right on the website. They gave me names of 2 attorneys who'd be willing to help. And I talked to them very quickly. And in like 15 minutes, they were like, no, you're fine. So don't call them at the beginning and be like, I'd like you to tell me the statute number, the case number. Can you send me a template and go ahead and do all the work for me? Okay, it's not that. It really is, you've taken your effort, you've done your due diligence, but it's a more experienced lawyer in that field. Many of them are board certified, and they're really willing to help you, kind of give you that last push or maybe put it in the right direction. I also called one time because I'm like, okay, I'm in a different county than I'm normally in. And I know there's what the law says, but I also know there's how the judge runs the courtrooms. Can you guys give me a little insight as to what I need to be doing and why this isn't working? So Lawyers Advising Lawyers is a great option. Again, that Florida Bar Ethics hotline is magic. Legal Fuel is up on the website. That is basically templates. You can get attorney retaining letters, attorney, my case is over letters. It wasn't the breakup. It's just, by the way, I did a great job. It's over. Thank you for your service. My relationship is done at this moment, unless you re-engage me. There are attorney-client agreements. There are confidentiality agreements if you're hiring contractors or investigators or a legal assistant. So those are really great resources that are out there and available to everyone. So let's do kind of the takeaway today. I'm going to run through each one of our panelists. And by the way, thank everybody so much for being here. It's been truly fantastic. But what I want to do is, panelists, just kind of think for a second, if there's one thing you wish you had known about the attorney-client relationship when you were just starting out, what's one thing you'd like to share? I'm going to go straight down the list as I see people on the screen. So Josh, I'm going to start with you. What's one thing you'd like to tell the group about the attorney-client relationship?
Again, I think they're people, number one. The client is a person. The more you talk about the client and the action and forget the fact that it's a human being, I think you need to remind yourself that you're out there serving that particular even if it's a corporation, the corporation is going to be people. The entity is going to be people. And the more that you realize that you use your people skills, your understanding, your empathy, and ability to represent that person and helping that person achieve their goals. It's not about you as a lawyer. It's about helping your client achieve their goals, the better you'll be.
Okay. Aman, what would you like to share?
I think just as a general rule is be transparent with your client and kind of expect that in return. As long as you're setting the expectation that you're going to be honest with them, you're going to give them frank advice, not just tell them what they want to hear, and that you expect the same from them, that can prevent any surprises later on if you find out a fact about the case that your client failed to tell you. Just be as open and honest with them as you can be and tell them that you would expect the same in return.
Armana?
I would just follow up with that, that Iman said, and just say, treat others like you want to be treated. One day you are a client and you may be a client. And how would you like to be treated by your lawyer? And try to do the same for others when you're helping them. You have to have that empathy like Joshua spoke about. And I like to follow that motto myself in life in general. So I would say that applies to the legal field as well.
Takesha, what would you like to share?
Be a good listener. Listen, listen, listen. Sometimes we're lawyers and we just want to talk, talk, talk. Sometimes we have to listen, listen, listen. I think sometimes we just have to take that moment, let the client get what they need off their chest, and then give our advice, then start talking. But sometimes that client just needs a listening ear, and I think we can be that listener.
Okay, Rachel?
So the biggest thing that comes to mind for me is, especially I think when you first come out right after you finish law school, you've spent 3 years learning all of the terminology and learning how to speak about it very quickly and go through all of a lot of times even the acronyms and things. I think one of the best things you can do as an attorney, whether you're doing criminal or family or what kind of law you're doing, is remember that your client most of the time doesn't want to be there. Whether it's that it's a situation that they were arrested and they don't want to be through that, or if it's in family, if they're dealing with kids or a divorce, it's really emotionally laden. I think a lot of times attorneys sometimes will forget to stop and explain the process and explain exactly what's going on, especially as they're doing it. I joke with my clients all the time. I'm like, the only people who like coming to court are lawyers. Everybody else has no desire to be in court. So my clients a lot of times we go through court very quickly, especially if it's a reset or a quick arraignment or things. It's maybe a minute and a half court date, and we're throwing language back and forth that the judge and you and the state understand, but the client is like, what are you talking about? And I think you can win so much credibility and really benefit and get a stronger relationship with your client if you stop and say, okay, let me explain what just happened, or before the court date saying, let me explain what's going to happen. And then they don't feel so out of place in an experience that's already really scary for anybody but lawyers. So, or even scary for lawyers, depending on the judge. So.
Well, I thank everyone for being here today. And for everyone who's watching this at home, I thank you for paying attention and for your time. The takeaway from me is, first of all, happy client is going to be happy lawyer at the end of the day. It's going to be much easier to practice and have a good law practice if your clients are happy. And part of that comes from any relationship, having realistic expectations, knowing what the expectations are, talking about the uncomfortable subjects up front, like money, talk about when the relationship will end, when it starts. And most of all, there's help out there. So there's help from other lawyers who are more than willing to be a good ear and a sounding board. There's help from the Florida Bar. And don't be afraid to evolve. Over the past 20 years, I'm sure my techniques have changed slightly, and hopefully they've gotten better with time. But for everyone, again, thank you so much for listening today. I wish you a happy week. Be safe and be well. Thank you.